Hello, I'm Robert Emmett Hernan. I'm head of Blue Stack Productions, the publisher of Irish Environment, an online magazine covering environmental matters on the island of Ireland. I'm very happy to be here in Dublin with Attracta Uí Bhroin, who's from the Irish Environmental Network. You're very welcome, Attracta.
Thank you very much.
It's nice to see you. Now, Attracta, I know you've been actively involved for some time with the various international trade agreements affecting the European Union and Canada and US and others. And I thought we'd spend our time today talking about those. And if you could just, to the audience in just very general form, tell them what these trade agreements are. The comprehensive economic and trade agreement, which was with Canada, and the TTIP, which is the transatlantic trade and investments partnership with the US and EU. If you could just in general terms tell the audience what the...
Okay. Well, the EU is in the process of currently negotiating a number of major trade deals. And just, I suppose, to put this in context, the trading relationship between the EU and the US is absolutely ginormous. It's $2.2 billion of goods and services are traded daily. It's about half of world GDP. And it's probably the most major trade deal that has ever been negotiated. And that's referred to as TTIP, which stands for the Transatlantic Trade and Investment Partnership Agreement. Now, CETA is the comprehensive economic and trade agreement with Canada, and both of these things are happening a little bit one ahead of the other. CETA is very much nearing conclusion. It's effectively, the agreement is written, it's just going through those final stages, whereas TTIP is very much sort of still evolving. There's still negotiations ongoing in relation to what is being agreed. Now, from our point of view, trade isn't bad. Ireland is an open economy. Clearly, as a former emigrant, an economic emigrant, we know the importance of trade. So it's not an issue with trade itself, it's the environmental consequences and the social and democratic issues that arise out of these trade agreements that are of concern to us.
Now let's so we all know kind of the basic benefits of trade. Open trade is useful, unless it has the consequences which we're worried about. So let's go through some of those key provisions. Before we get to the critical one, the dispute settlement issue, the right of foreign corporations to influence Irish and EU regulation. What's the issue there?
Well, basically, the term that's often used for this is sort of regulatory convergence. So basically, you have two partners, basically, with different sets of standards, different sets of rules and regulations, etc., on either side of the Atlantic. And we have, although we give out about the EU, it has done an awful lot of really extraordinarily good work in relation to placing demands on producers to adhere to certain environmental standards and health standards and welfare standards, indeed, for animals. And there's been a lot of very, very good regulation in relation to that on the EU, whereas in the US there are different regulatory regimes. And, for example, things that are permitted on the other side of the Atlantic, like chlorinated chicken and hormones, etc., and the extent of hormones that are allowed in food products effectively are quite different. So the issue is, if basically you're allowed trade and goods are moved from one side to the other, how do you deal with the different standards? And basically what's proposed is regulatory convergence, whereby standards basically merge. And I suppose the issue is there is a concern that instead of that being a hiring of standards, it will actually be a race to the bottom, and it will pull the EU standard down. And it will also inhibit the EU in actually advancing in the manner in which it has done in the past. And one of the big things that we have in the EU is, and it's embedded in the treaties underpinning the whole European Union, is the precautionary principle. Right. And this is absolutely critical, because the way things work in the EU is that if in doubt, leave it out. It's the principle of scientific certainty. Unless you can be absolutely certain with scientific certainty that something isn't going to have an effect, then you don't pursue it. Whereas on the US, as I understand it, it's quite different, where basically the precautionary principle doesn't exist, but the obligation is you have to prove that there's an issue in order to actually remove something. And that's a huge discrepancy, and how these things will be resolved and what the net effect will be is a cause of huge concern.
Provisions about regulatory control and merging of regulations would apply in the Canada treaty as well as with the American.
Well, the same issues arise in relation to if you have different partners with different regulatory regimes, how do you actually facilitate trade between them?
Okay. And now, certainly the biggest item that's been subject to the biggest dispute is the investor-state dispute settlement in the CETA as well as in the TTIP. So could you tell the audience what that dispute settlement mechanism is and what the problem is with it?
Well, fundamentally, investor-state dispute settlement mechanisms are something that have been around for decades. And effectively what they do is facilitate big business, and it is big business because there are certain rules in relation to the classification of structures that can engage in this, to sue governments effectively for making regulation or acting in a way which impacts upon their profitability. Now, these have existed in the context of bilateral investment treaties for a number of years, but for a country like Ireland, we haven't historically been involved in these up to the Energy Charter Treaty, and yet we've managed to attract a very high level of foreign direct investment. So the issue for Ireland is that because of that very high level of foreign direct investment, we stand quite uniquely exposed in relation to these proposals. And what's being proposed now in the context of these EU trade deals, both with the US, the TTIP, and with Canada, and the CETA, is sort of a new improved version of ISDS, which is known as Investment Court System. Now that sounds very civilized, doesn't it? But it's not a court. And that's the real issue. It is very different to what we know of our judicial regimes. Even with the improvements that Commissioner Maelstrom has introduced, there is still a very considerable deficit. And basically these are arbitration systems which sit outside of the national courts, which allow business sue states for taking action in a way which impacts upon their profitability. And this is a very real thing. For example, the state of Quebec has been sued by Lone Pine for introducing restrictions on fracking for upwards of 250 million. That even just the existence of this can cause what's known as a regulatory chill. Governments become frightened of introducing new regulation for fear that they will then be sued as a consequence of it. And it has huge implications in the context of the EU, where we basically have strong environmental laws, for example, like the Habitats Directive, which promotes the protection of species and habitats of community interest, and where certain types of restrictions can exist consequent on consents and what conditions are actually required. And where those impact upon business, you could actually end up with a situation where basically a member state is being sued for having applied constraints on a particular development because it needed to do that to be in accordance with the EU law. And that ridiculous situation can actually happen. Really serious questions have been asked by very expert bodies like the European Association of Judges, the Deutsche Richterbund, which is the German Magistrates Association, and very eminent scholars and legal practitioners about the legality of these proposals under EU law. And what we're now is in a situation where the CETA text has been finalised, and these proposals are coming fast down the track in terms of having real effect across the EU, and obviously of particular concern to us here in Ireland is the Irish implication.
As I understand it, originally the dispute settlement mechanism was to be private arbitrators behind closed doors, private arbitrators who typically work for corporations. And the new modification for that is that there's actually now a panel of, quote, judges appointed by the governments, 15 members.
Well, I think, as I understand it, basically the exact mechanism for appointment is unclear, which is a concern. There was big concerns in relation to the independence of judges. Basically, the Magna Carta for judges lays out the whole sort of necessary in terms of expertise, independence, etc. And some of the issues are, if you don't have security of tenure, then you're potentially not entirely independent. But these, as I understand it, this panel is only there for 6 years. There's no impediment to them working outside of that. And 6 years isn't really sufficient. So there's issues regarding the actual selection mechanism, which is unclear. They're expected to be, as I understand it, selected with expertise in investment. But when you think about the whole remit of areas that could be impacted, you know, a whole range of civil laws, environmental laws, everything come into play. And bear in mind, this is a one-way only disputes mechanism. Unlike in the courts where I can sue you and you can sue me, investors can sue the government, not the other way around. And a third party can't sue under this mechanism. So it is solely to the interest of big business. It is, in the words of Professor Gus van Harten, a profound shift of power. A profound shift of democratic power and accountability. The regulatory chill associated with this is effectively going to handcuff us in relation to climate action, which is the critical, obviously, issue of our age. The real issue here is that supply side and emissions, non-emitting technologies for climate are way down the road. So what is critical for us to address right now is the demand side, the demand for energy. And that needs standards in relation to design standards, emission standards, labelling standards, all the different things that basically big business are likely to push back hard on. So our ability to regulate and to legislate in order to be able to effectively deal with climate action is going to be severely compromised with the introduction of these new systems. Handcuffing is the way I look at it.
And is there any right to appeal from this panel of judges to the court system of any of the member states? Okay, so there's no right of appeal?
No.
Okay. All right, now, Attracta, you started earlier to talk about where CETA was going, and that's way advanced. TTIP is still under negotiations.
That's correct.
CETA was signed, but there's still some hurdles there. Why don't you tell the audience where we are with CETA at this point in time?
Okay, CETA, basically the text has been finalised, the agreement has been finalised, and what has happened now is there's a specific life cycle that's laid out in the treaties of the EU as to what happens next. And basically the Commission has made a proposal to the Council of the EU in relation to the signing of the agreement and also its provisional application. And I can just take those two steps in turn. Basically, the signing is a first step. The agreement will still need to be concluded, and the EU Commission has conceded that basically the agreement will still be ratified by each of the member states. So it will need to be basically agreed by the parliaments of the various member states before it is finally concluded.
By each and every one of the member states?
By each and every one of the member states. Now, that's a slightly strange decision because the EU, and this is where it gets complicated, has always insisted that it has exclusive competency, which means that it has the competency to conclude this agreement on its own.
On behalf of the member states?
On behalf of the member states. If it were a mixed agreement, that would mean that there is shared competency. It can't do a solo run. It effectively needs to co-pilot the landing with the member states. But there's sort of been, I think, a political concession here, is my reading of it, so that they have said, okay, look, we will allow the member states to ratify it. Now, provisional application means that pending the ratification by the member states, elements of the agreement effectively come into effect. They go live. And there's huge sensitivity around what elements of the agreement will be allowed to go live before the member states have their say. And one of the most sensitive ones is the investment chapter, which deals with this investment arbitration system now known as Investment Court Settlement, ICS, that we discussed earlier. But in October, around the 27th, it is expected that the CETA agreement, will be subject to big photo op and effectively will be signed, and then it will move into the ratification stage. The extent of provisional application is what we're all waiting with bated breath on, and that's quite a complex thing. And I suppose there are two key things that we're really looking at in relation to the member states having sensible guidance from the Court of Justice on the extent to which they should deal with this provisional application. And we're urging them to wait on a decision of the Court of Justice on another trade deal, which asks the Court of Justice questions about where the EU has competency and where the Member States have competency. And that effectively is very important in determining to what extent legally can the provisional application on key areas like the investment chapter be applied. The second area where we're actually hoping that there will be a reference made by the institutions, or indeed through some action from one of the Member States, somebody taking an action, maybe an ENGO or a public-minded individual or a public-minded business indeed, taking an action which results in a reference to the Court of Justice, which is effectively asking the Court of Justice a question so the Court can advise on the actual legality of investment arbitration proposals in the CETA under EU law, because there are very serious questions about the legality of these proposals. And what is of serious concern is that governments appear to be willing to go into this blinkered without that advice from the Court of Justice. And it seems eminently sensible and a very reasonable thing to request that they await that.
It seems to me conceptually strange that they would agree to provisionally apply something like the dispute settlement and then send it out for ratification. If it doesn't get ratified, then what's the legal effect of a decision made under this provisional?
I think a lot of very happy lawyers.
Yes, that's right, that's it.
But yes, you could have a very interesting situation where something's been agreed under international law, but to what extent it would then not be able to be concluded under EU law, and the provisional application would have been brought into effect. Now, obviously, there's been an agreement that the agreement can't be concluded until the Member States have ratified it, but you could have this odd situation with something having been provisionally applied which should never have been applied.
What's the Irish government's position on CETA?
Good question. It's been asked a few times in our Parliament. We haven't really got satisfactory answers, which again is a huge concern in relation to democratic accountability. Our understanding is that there is an appetite for investment arbitration on behalf of Irish business. So to facilitate them being protected when they trade abroad. Now, when one thinks about the balance of that, the balance of interest, a handful of Irish companies trading abroad, for what level of interest? By virtue of leaving the taxpayers and the citizens of Ireland exposed with our huge level of foreign direct investment to being sued for regulation. I'm not quite sure who's doing the maths here.
And I don't think we're going to find out soon.
I don't think we're going to find out soon.
Attracta, thanks for talking with us.
Okay, thank you.